So we go back to, so now 254, you've decided you're going to stand up for first of all, you've been let down, so you've lost hope. How do you end up at the BBI court?
So,
At
I
the
was
Supreme
actually
Court?
telling you how I became interested in law. I think we were in med school where I helped draft the constitution. Even after that, I still was interested in a lot of things that were happening, especially because we had a young constitution, and and there are things that are in the constitution that I disagreed with. There are things that are not in the constitution that I would have wanted there. Okay, but you see,
Examples?
I'm a believer
A few
that
examples.
I would have probably wanted to have a more powerful parliament and a less
A
powerful
lot of people are
president.
saying the parliament is powerful but captured.
No, I think the president is the most powerful office in our country. Maybe it may not be expressly written in the constitution, but our constitution is interpreted even based on our practice. Okay? Yes. And even just the fact that the president is the one individual who receives votes from everyone in the country, I think that's even from a democratic perspective, that's really the most powerful individual. Okay? And to a large extent, parliament has power to check the president. But again, the president generally has ways of bypassing parliament. Like, parliament cannot check the person of the president. Parliament can only check the office. You see, it cannot check the person. In fact, in checking the presidency, it can remove the person. Okay? It can remove the person, but really it can't do anything to the person. You see? And then the way our party politics are, the party that is in parliament, majority in parliament, usually will be the president's
It's
party.
owned by the
Yes.
It's owned by
Yes.
the president.
So essentially, by our practice, the president is quite powerful, and I would have wanted the president to be less powerful. But it is what it is. What we have is what we have, and we have to be honest to what we have. Okay? And a big part of what I noticed between 2010 and 2016 is there are those activists. Let me start from 20. In 2010, there was a lot of compromise that had to happen to birth this document. Okay?
Part of the reason why we remained with a powerful president.
Yes,
Yeah.
that was part of the compromise. But that compromise is part of our constitution. You can't betray it now. You will just have to live with a powerful presidency because it was part of the compromise. And what I felt like between 2010 and 2016 is that the losses that part of the society suffered from the compromise. The fact that they had to give up some things, they were trying to sneak them back in between 2010 and 2016. They were trying to emasculate the presidency. They were trying to expand the power of the independent institution, and particularly the judiciary. And they were doing it in a manner that is betraying the spirit of the compromise, the 2010 compromise. Because my feeling is, if you still feel like we need to weaken the president further, then let's just take the route that we had to take to arrive to this 2010 constitution. Don't try doing it by craft, by judicial craft, maybe parliamentary, legislative craft here and there. No. If we remained with a powerful president, it's because we wouldn't have had a new constitution if we didn't compromise. We had, how many years had we...
That was actually the trap.
How many years had we fought for a new constitution unsuccessfully?
Because I understand from people who were in Russia during those last 3 weeks,
yes,
that they had actually settled for a parliamentary
system. Yeah.
And so, because they wanted to throw a spanner in the works, they brought back, and it's actually the current president, they brought back the presidential system,
yes,
so that Raila would be
Oppose
triggered,
it.
would
Yes.
oppose it, and then the system would collapse.
Yes.
No, the process would
Yes.
collapse. But then he saw through that and said,
yes,
okay, I'll compromise. Let's go.
yes, and it's because the constitution did have other good things, which whose fruits we are enjoying even today. So I usually feel that when you now interpret our constitution only using the eye of the ones who wanted a weaker presidency and forget that we actually arrived at a compromise, and that is why I disagreed with the jurisprudence that the president has no power in appointment of judges. I was like, no. Why did we then write it there? Why did we write the president? Why did we introduce the president's role in that process? In our constitution, do we have any ceremonialness of the president? No, we don't. And if we intended that to be, we would have just said it over there. So I was like, no, the president still remained with some power in the process of appointment of judges. It's just that he had to share that power with now other institutions. He could no longer abuse it, as Moi would do, where Moi would want to appoint a teacher to become a judge. And so what he does is he picks someone and appoints them. So now we said, no, now we will have a JSC. And the JSC was there even before the 2010 constitution, but it was really composed of appointees of the president and fully, and it didn't have really the powers of independence. Okay? So now we gave an independent JSC the role of recruitment. You see, the role of recruitment, so that now the president, if he must appoint, then he can only appoint from persons recruited by JSC. And for me, I felt that was the better the interpretation that would make most sense, that would balance both the independence of the judiciary, the fact that, in fact, the president is the one who, in the text, has the power to appoint, in the text, you see. And two, it would still show the limitation that the president has. You see, it will play out the role of the JSC in limiting the president's power to appoint judges. So when the president said, I will appoint everybody else, I will not appoint these 6, and the president has their reasons. Because remember, the president is elected by the people to make the most important decisions for them. And we need to have a culture where we allow the president to make those decisions, and then we hold the president accountable for those decisions. Because tomorrow, suppose those judges that were appointed, the president was actually right, that they are corrupt. Okay? And I say this, I'm not saying they are corrupt. In fact, probably maybe they are not. Okay? But the president said, based on the intelligence that Kenyans have given me tools on how to know things more than other people, I have the intelligence that reports to me, I have this and that, and Kenyans have not compelled me to tell anybody else. They've only entrusted me and only me with that information as their president. Okay? And I am telling you, this person is not good for the country, so I will not appoint them. Surely for you to stand somewhere and say you know better than the president, I think you'll have to tell me more. Okay? And then for you to go ahead and say that those guys can be deemed appointed regardless of whether the president appoints them or not, that the president is compelled, what you're telling me is that JSC is the one that is going to have the absolute power. And you know, absolute power corrupts. Okay? It corrupts anyone. So if you decide you want to transfer, not share, transfer the power of appointment of judges from the president and give it to JSC, which is again an absolute entity, they will abuse that power. And you remember, I think Nasir used to say that JSC is also abusing their powers. They're actually intimidating judges. They will do that.
And he was a member of the JSC, wasn't he?
Yes. They will. Some LSK used to say that some judges are intimidated by Kina Ahmed Nasir. Do you remember?
Yeah.
Yes, they will abuse that power if you give them absolute power. And so the proper interpretation would be, and Article 10 tells us, this constitution requires the sharing of power. So let this power be shared between the president and JSC.
And I guess that would be the epitaph of the Uhuru presidency, because the constitution actually, as you describe, the 2010 constitution required a lot of sharing and compromise and wisdom. For example, around devolution, I think he chose to try and kill devolution and centralize power. Part of the struggle with KMPD was that, he promised the doctors, then the then unions, that they will bring back healthcare to the center. I saw they starved the devolved units of funds that were meant to implement, to actually implement the devolved healthcare system. And of course, there was those chaos of then strikes and that kind of thing. When you could easily have sat down with the 47 governors, so the 48 governments could have sat together and devised a way to make this work, but he chose not to make it work. Mostly, in my opinion, for entrepreneurial processes. Because remember, the first act of his government was actually to buy the medical machines, and one of the most corrupt ministries in Kenya since independence is the Ministry of Health.
The moment you give any one entity a lot of power, they will abuse it. It's not a new thing. I think this was said by this famous Roman senator. Power corrupts, absolute power corrupts absolutely. You see, so the moment we centralize power, the moment we make one person to be, they will abuse it. And so what we want is to share power as much as possible, have there be checks here and there, and then the ultimate person who has the potential of abusing should be someone who is accountable to the people. You see, so me, I would not want to know that JSC is the one that is accountable to the people politically for its political decisions or for its appointive decisions. Because how will I hold JSC accountable? I never appointed them. I never elected them. I can't remove them except on very specific grounds. You see, but you see, the president, I can remove them every 5 years. I remove the president. I elect a new person. I give them a fresh mandate. You see, I can impeach the president anytime for any reason. In fact, if you look at the impeachment provisions, they actually really expose the president. They make the president impeachable for anything. You can impeach the president merely because you believe he has committed a crime, even if later you find he didn't commit a crime. But merely because there is reason for the MP to believe the president has committed a crime, they can impeach the president. And like, once impeached, that's it. You see? So these are people who we can hold accountable. But then
only if you had a function of parliament.
Yes. But legally speaking, we can't hold them accountable. Practically speaking, now that's a different thing. Okay? But how will you hold JSC accountable? You can't. JSC officials can't be removed by parliament. They can't be removed by the president. They can't be voted out by the people. You see, they have to go through a tribunal that is a judicial tribunal. And judicial tribunals do not look at the politics. Judicial tribunals do not look at what is good for the country. No. Judicial tribunal look at what is the law as it applies to this individual. But this is a state officer. A state officer cannot force themselves to serve us. If we don't want a state officer to serve, they shouldn't serve. You see? And so where we've decided we are protecting certain state officers, then we shouldn't give them absolute power on any decision. There should be a way in which their discretion can be tempered by another person's decision. Because ultimately we hold our president accountable. You're the one who appointed these people.
Now, I'm looking at your passion on these issues.
Yeah.
Are you going back to school to do law?
Yes, I will. I'm actually a student of law.
You're in school now?
Yes. I'm a student of law. Yeah. So that was it. So when we looked at BBI as a 254 Hope, when we looked at BBI, we felt that I read BBI actually from page to page, those proposals. And I actually used to do breakdowns, like explaining what this chapter talks about, why they have said they want to do this, why they are doing it and whatnot, why they are proposing this and what it will do, whether it will actually serve the purpose they are saying it will serve. Because these politicians usually use smoke screens. They tell you they are doing this to do this. I saw the other day senators saying that they want to create to introduce an amendment that stops former governors from vying for any MP seat, either Senate or MP seat, saying that is because the Senate will not play a proper oversight role over their previous functions. I looked at it and I was like, these guys there are other wars they are fighting. This has nothing to do with accountability. These are other wars they are fighting. The senators just need to hold the people who are in office accountable now. Once they are out of office, it's now no longer their role to try and hold someone who's no longer in office accountable. Political accountability is what the Senate is about. political accountability for the people in office now. Legal accountability and criminal liabilities, those are left to they are left to the judicial organs. Those ones can hold them accountable even after they are out of office. But let's not. So essentially,
Personalizing is like you're
yes,
personalizing
yes,
legal judicial system.
yes. So it's the same spirit where politicians tell you they want to do this for a certain good end, but really they have ulterior motives, is what we noticed in a big part of the BBI. The BBI had some good things in it, but then it also had some things that I could see. There are forces that failed in 2010, and they were trying to entrench some things now to reverse some of the gains. I got the feeling that that at 2010, the leadership or the polity or the, what should I call them? The system. This thing the guys call the system.
Or deep state.
Yes, or deep state or something, did not really quite understand how powerful a constitution is. They probably thought this new constitution will just be a piece of paper like the old one. And so during the compromise, they ended up accepting some things that they later learned were very
Actually,
very
when I
serious.
read, because I also read it cover to cover, just as you did,
Yes.
I asked myself, who pushed within the system, who pushed this constitution through and convinced Mwai Kibaki and Raila Odinga and other politicians to support it?
Yeah.
Without them knowing that this is going to
Yes.
tie their hands and
Exactly. I think some people didn't know how strong, how powerful the constitution would get. I think it got a life of its own and became very powerful. And so some of the things they had previously agreed to, they wanted to reverse them. And an example,
the process started immediately, actually.
Yes, and I think one of the things that I remember reading in the constitution and in that proposal was the issue, I think, on property. They were strengthening the property right, and yet I was not persuaded that as a country we have had any serious problem with property rights that needed a constitutional intervention. But what they wanted to do is to entrench the property rights in such a way that, including land rights, such that we will not be able to go back to
address historical injustices.
To address historical injustices. I saw the issue about expanding African something. They wanted to the Pan-Africanism. They wanted to entrench it in the constitution. And I looked at it and I was like, okay, what is the goal here? Because we already have the tools necessary to get into bilateral arrangements with other African countries, but we're really insistent on entrenching it in the constitution. But we don't know those other presidents. We've not elected them. How do we? It's almost like signing a treaty. It's almost like signing a treaty and then entrenching it in the constitution.
Or signing it in advance when
Yes.
you don't even know what will be the content of that treaty.
Yes. It's something like that. And I was like, no, we can't do that. We cannot get into a constitutional, we cannot tie ourselves constitutionally to have someone like Museveni govern over us as he wishes. And so I looked at some of those things and I was like, and then I think they were also amending some of the amendment procedures so that they would make it harder to re-amend the constitution. You see? So I looked at that and I was like, here there's a very clear intent to, number one, reverse some of the gains we made, but reverse it in a very calculated manner. Because a constitution is not usually really the words that you see. A constitution is the interpretation that those words are given. Okay? And so the moment you enhance the right to property and land rights and whatnot to cover even those historical injustices, that will just be a halt on any resolution of those disputes. It will be like, I mean,
So
zilipitwa na
maybe
wakati.
you won't say it, but basically what
Yeah.
you're saying, because BBI was being pushed by
Yeah.
Uhuru Kenyatta
Yes.
and Raila Odinga,
Yeah.
who is actually Uhuru who was protecting the Kenyatta family from
Very likely. I
Yeah.
could see that from reading those things. Reading, it wasn't the kind of thing that you will see it in the words.
I mean, what was clear in the words was
Yes.
the one man, one vote,
Yes.
which is what the politicians were pushing,
Yes.
the sweeteners.
Yes.
But the real thing, the real, flesh of it, the judicial, which they're also dangling the judicial
Accountability,
ombudsman and
yes.
that kind of thing, which is things that were alive.
Yes.
Kenyans were talking, we need a more accountable judiciary,
yes.
we need whatever.
Yes.
But the main things are what you're talking about.
Yes, and those were not being talked about, and even where they are there, they are hidden. So we looked at it and we were like, no. And then now, aside from that, and I don't really believe that that Kenyans cannot alter the constitution if they want. They can alter anything.
The basic structure doctrine.
Yes.
Tell us about, you challenge that.
Yes. Now, when we started out the BBI, in fact, the time when BBI just started, forget even the time it got to court, I really got invested in constitutional making, and I read a lot about the doctrines that govern constitution making. And one of those doctrines was the basic structure doctrine. Initially, you remember BBI was to go through a parliamentary process. It wasn't to be a popular initiative. It was to go through a parliamentary process. The team was to come up with a bill, then the bill is tabled before parliament, and then it would eventually go to a referendum if parliament fails to pass it, or if it touches on certain things that require a referendum. That was how it was supposed to happen. This whole signatures thing and whatnot was not there.
That was a political game.
Okay. Now, at that time, I started trying to look at the basic structure doctrine, because the basic structure doctrine is basically a doctrine, and I'll use an allegory. Assume I'm your boss, okay? I give you some work to do. I write down on a piece of paper and tell you, I'm delegating this authority to you. I want you to do this and do this and do this. You will be able to transfer some of the junior staff to other department. You will be able to do this and that and that and that. However, there are the following things which you have to ask me before you do, but you can do, okay? And then, and then I give you the document, okay? Can you later on use the authority that you have to change this document? No, you can't. Okay, so that's basically the basic structure doctrine. That document, there are certain fundamental things that are in it that you cannot change it as a delegate. You as an institution under the constitution cannot change certain aspects of the constitution fundamentally. And that's why it's called basic structure. That there is a basic structure to every constitution, which doesn't really matter how much amendment powers we've given you, you can never change it. Even if in the constitution we have said you can amend anything, that anything does not mean everything. Okay? There are certain things. For instance, you cannot convert yourself as parliament to become a monarch using the powers given to you by this constitution. That is basically the basic structure doctrine. Okay? So, initially, I thought the basic structure doctrine is applicable in this situation, in the sense that there are things that parliament cannot amend. Okay? And I think it's obvious. Our constitution, even just in the fact that we have provided some things that require a referendum, that tells you that there are certain things in the constitution that are core.
They're actually quite stated.
Yes.
There are those things that require two-thirds majority, so the people can amend.
Yes. But then, the whole BBI process took a different turn. It stopped being a parliamentary process, and I think the president and Baba and the other functionaries probably were advised that
because they
going
realized
the parliamentary route.
First of all, Uhuru didn't have the parliament.
Yes.
Ruto had captured it.
Exactly. You might go into the headwinds of the basic structure doctrine. You see? And so they decided they'll go the popular initiative route. Okay? So that at the time when this matter was being filed in the High Court, I didn't think this matter relates to the basic structure doctrine. Because the basic structure doctrine is a limitation on Parliament's power of amendment, not the people's power of amendment. Okay? However, my problem was a popular initiative must be a popular initiative. A popular initiative is not a popular initiative. It is if it is being bankrolled by the state. The state is not the people. There's a dichotomy in a constitutional regime where you have the people and the state, and the two are always in contest. Okay? They are always in contest, the people and the state. Somewhere in between, there is parliament, which is both the state and the people's representative. Okay? But there's usually a dichotomy and a conflict between the people and the state. And the two cannot be considered together in a constitutional setup. The two are distinct.
And I think we actually, our constitution actually makes that quite clear. At the beginning, the first chapter.
Yes. So when these guys were taking the route of a popular initiative, but then bankrolling it using state machinery and state functionaries, and the president signing off as president, I was like, no, this is not a popular initiative. This is a state initiative, but the only way the state can initiate an amendment is through parliament.
It's through parliament.
You see? So this is a state initiative that wants to bypass parliament. No, that's not it. So for me, my problem was not that the basic structure doctrine is applicable or not. In my opinion, the basic structure doctrine was not applicable in this particular initiative because it's a popular initiative. Okay? And I'll tell you why the basic structure doctrine or any doctrine ought not to be applicable in the popular initiative to try and limit that power. I'll tell you that later. But for us as 254 Hope, basic structure doctrine was not applicable in this particular dispute. It would have been applicable even as a dispute if we were going through the parliamentary route. But these guys had declared they've collected signatures. They are going to the popular initiative. Yeah. So here, if there is any reason to stop it, it should either be that this is an unlawful popular initiative, you see, or another doctrine that maybe we can come up with later. But as far as this was concerned, this was a popular initiative, but not a proper popular initiative. And for us as 254 Hope, that was a problem we had with it. You see, that the state was bypassing parliament
and masquerading as
the people. But the state is not the people. In a constitutional regime or in constitutional theory, the state and the people are distinct. You see, sometimes the people can include the state. The people can include the state, and all the functionaries and whatnot can be included in the people, in we the people. Okay? But the state can never assume itself to be the people, and it can never itself go seeking to merge with the people. No, it can't. And our constitution, through the popular initiative, has already created the role of the state, okay, acting within the ambit of the people. That is, let a person who is interested in amending the constitution go out there and collect 1 million signatures. That process is so difficult. But if you can raise 1 million signatures, means you've persuaded 1 million people to back you, then it means that amendment is actually valid. You see, it means there are 1 million people who have actually been persuaded that we need to change this. Because it's a difficult process.
It's a very difficult process. Yeah.
But it's a very easy process when it's the state doing it. You see, so what I wanted the court, by the way, to adopt was a doctrine of difficulty in amendment. That amendments are deliberately made difficult, okay, by the Constitution, so that they are justified.
They're not frivolous.
Yes, so that they're not frivolous amendments. And when the state assumes its role as the people and decides it will take up the role of collecting signatures, you are actually easing the work of amendment and this constitution will become a piece of paper like the old one, if you allow that. Okay? So that was the problem we had. And so when we approached the court, us initially at the High Court, we actually told the court that the basic structure doctrine is not applicable in this particular situation. And so we actually argued on the same side as the government as far as that particular thing, the basic structure doctrine, is concerned. Said it's not applicable, and even if it were to be applicable, it's not applicable in the manner that the guys who've sued for it are asking. Okay? However, this was not a popular initiative. So the whole process is unlawful because it's not a popular initiative. The only way the president, sitting as president, not as Mr. Uhuru Kenyatta, the only way the president sitting as President Uhuru Kenyatta can seek to amend the constitution is to use the channels that are provided for the state, which is let the president and the executive sit as cabinet, let them come up with a cabinet resolution that they think we need to amend the constitution in this manner. And as president, I'm advising because I am the one responsible for maintaining national unity. And a task force has advised me this way. So we give it to parliament, and parliament deliberates it and passes it.
2/3 majority.
Yes, by a 2/3 majority. And if any of the items there require a referendum, it be taken to a referendum. But don't disregard parliament, the route you have been given, and then seek to stand as president and say you're signing a popular initiative and bankrolling it using the exchequer. No, that was what we had a problem with. But again, another thing that came up in the BBI dispute, which we as 254 Hope actually distinguished, was whether Mr. Uhuru Kenyatta can lead a popular initiative. Mr. Uhuru Kenyatta and Mr. Raila Odinga, they can. They are people. They are part of the people themselves individually. And so, if Mr. Uhuru Kenyatta, and I think you might remember when I was at the Court of Appeal or Supreme Court, I kind of called out the side that was against BBI. Okay, my colleagues.
Your colleagues on this.
I called them out and told them, surely you can't tell us now that you cannot separate Mr. Uhuru Kenyatta and President Uhuru Kenyatta. Yet we know Mr. Uhuru Kenyatta pays school fees for his children. We never confuse that he's paying it as president. He pays it as Mr. Uhuru Kenyatta. So we know when he's doing things as president, we know. And we know when he's doing things as Mr. Uhuru Kenyatta. So if Mr. Uhuru Kenyatta wants to lead a popular initiative, he may.
And he can finance it from his own pocket. He can
finance it from his own pocket, and he can go out as Mr. Uhuru Kenyatta and seek guys to sign signatures. You see, something that CORD had tried. You remember CORD tried to raise signatures, and they were doing it as an entity separate from the state, as a political party. And by then they had a big problem. You saw even how hard it was. CORD was the most popular party in the country, but they were unable to raise 1 million signatures, 1 million valid signatures. So it's not an easy job, you see. And so if Mr. Uhuru Kenyatta wanted to do that, or even if Jubilee or were they called NASA?
Was it NASA then? Yeah,
they were called NASA.
Yeah.
If Jubilee and NASA had decided to come into a coalition as political parties and they wanted to amend the constitution by popular initiative, they could have done that. They could have gone as political parties, collected signatures, okay? Political parties led by Uhuru and Raila Odinga collected signatures without involving the exchequer, without involving public funds at all, without appointing a task force using presidential powers. You see, go make your proposals, take them to the people, get 1 million signatures, and I would never oppose it because it would mean this is a valid popular initiative. That's where we had a problem. So anyway, we litigated it all the way to the Supreme Court. I was rather disappointed.
How was that experience? Because here you are, a medical doctor, no lawyers, no, you didn't have a lawyer representing 254 Hope. You are in the arguing this case in front of the Supreme Court, together with the so-called working constitutions. We had, senior counsel Orengo in the room. We had, I think, senior counsel, what is this? The former ombudsman who's currently the MP for Kenya. Otieno Bolo were in the room, and such luminaries of the legal profession. How was that experience?
It was quite overwhelming. It was quite overwhelming. At the High Court is where I had the most problems because I didn't know how to talk in court. I was talking too fast. In fact, at some point I was literally reading my submissions. And Justice Joel was quite gracious. He kept telling me,
Joel Ngogi.
yes, kept telling me, relax, stop reading. I want you to tell us because I can see you know what you're saying. So just tell us. So I had a bit of a problem at the High Court. But by the time I got to the Court of Appeal, I had gone through the document so many times, I knew exactly my sticking points and my issues. And I had an interesting experience at the Court of Appeal because now the matter, I think, had taken a bigger appeal.
It had become even more political.
Yes,
now.
it had become more political and more national. And I remember the other BBI opponents who had also filed suit. They sought to form a big team of all of us so that we fight together. Okay, but remember, right from the High Court, there are things I didn't agree with, even the other litigants. The reason is, if we push for a basic structure doctrine against the popular initiative, it will mean we will never be able to amend certain parts of this constitution, even as the people, unless we orchestrate a coup. You see, that's what I had a problem with. That it will mean, if we endorse the basic structure doctrine as a permanent and absolute bar to amending certain parts of the constitution, we will be tying ourselves and future generations unlawfully. And I don't really believe any generation has the power to tie future generations. Absolutely. You see, let the future generations
or even
be able
current
to
generations.
decide.
As in 2 years from now, as
Yes.
you said, if you're able to raise 1 million signatures,
Yes,
we should,
you
be able to
amend.
we the people should be able to amend
Yes.
anything that we want.
Yes. And at the very least, the constitution, the difficulty in amending the constitution should be just as hard as the one that is there. But you should never make it harder. You see? And that's what I was feeling like. Endorsing the basic structure doctrine as an absolute, endorsing it as a limit on parliamentary powers still leaves the popular initiative. But endorsing it as a limit even on the popular initiative was, to me, another ploy by the politicians to entrench certain things, or those who entrenched it that time, who entrenched certain things. And remember, it was a compromise. So you entrenched certain things and then you want to lock us in there. Absolutely. I was like, no. That's why I was opposing it.
And I think, and I think by the time you're getting to the Supreme Court, I remember you were given, you had been promised 40 minutes, I think.
2 hours.
2
I
hours.
was supposed to do 2 hours.
And then
they reduced it to 1 hour. And then they eventually gave me 45 minutes.
45 minutes.
Yeah.
And I remember you didn't read.
Yes. I did read.
I think that was what really caught my attention.
Yes.
You were now able to articulate without reading.
I think I've even shared this with you. At the Court of Appeal, I was going to tell you something that happened at the Court of Appeal that was a bit disturbing for me. So we are these activists who filed against BBI, all of us. So we are in this group, and there are some issues that I didn't agree with them. For instance, I didn't agree that Mr. Uhuru Kenyatta should be made personally liable for the funds that had been spent, because the president had acted as president in the true belief that he had the power to do that. Okay, so to hold him personally liable, I thought was quite unfair. Okay, number two, on presidential immunity, I was of the opinion that under our constitutional regime, however much you might want to say that the old constitution is what gave the president absolute immunity, the wording is exactly the same. We didn't change. As far as presidential immunity is concerned, we never changed anything except one. In fact, we even increased the immunity of the president in the new constitution, the 2010 constitution. The only thing we changed was that the old constitution did not have the exclusion on presidential immunity with regard to crimes against humanity or international crimes for which the president is accused. And you remember, that was even added at the last minute when it started seeming like guys would want to use that to run for president so that they avoid being in the Hague 6. You remember? So it was added even specifically for a specific goal. So I was like, to now purport to read the new constitution, which is the exact same wording as the old constitution, in fact has expanded the immunity more, but now to read it as though the president can be dragged to court and the old constitution did not allow that, surely you're lying to us. So I told them, I may not be a full supporter of absolute presidential immunity, but it is what it is there.
It's what,
It's what is in the law. If you want, change it. But do not, by judicial craft, try to say the president is not absolutely immune in Kenya. He is. Until he leaves office, that is when he will be covered by this other normal immunity. The immunity of public office immunity, which other people are covered with if they did the things in good faith and whatnot. Okay? And then immunity from criminal things also ensues. You see? So that I disagreed with them. And so I told them that I'm not. So when I think they saw that I was unwilling to compromise, because they offered to give me an advocate. I told them, no, I'll just get my own advocate. At the Court of Appeal, I actually needed assistance from an advocate. And I had actually gotten someone to help me at the Court of Appeal. But these guys actually reached the guy. So now I'm insisting that no, we are not going to endorse the basic structure doctrine. But my advocate, who prior we were on the same page, suddenly just said, no, let us do this and this, and whatnot. So I was like, no, we are not going to do it. And fine, I'm the one who has the final say as far as how my case will be prosecuted. So he declined. He said that if one day to actually appearing, because we were filing the document on, I think on Wednesday, and on a Thursday, we were starting the hearings at the Court of Appeal. Or like it was, we were filing today and tomorrow we were starting. And on the day of filing, the guy tells me, if you're insisting on the presidential immunity thing and that the basic structure doctrine is not applicable as the way it is, then I'm not going to appear for you.
He doesn't want to go on record.
Yes, he'll not go on record. Okay? So I told him then it's okay. The good thing is, I had actually personally been working on the submissions. So that evening we were just supposed to merge. Okay? We were just supposed to merge. So I mean, it was easy for me to just, now take my document and just add some of the things that we agreed on here and there and whatnot, and maintain the arguments that I felt were. So I understood the document. I knew it very well. So I filed that evening. The next morning, the guy was actually appearing for one of those other fellows. I felt a bit disappointed, and I felt like, I feel like even as activists, I know eventually there are certain goals we want to achieve. If we were politicians, for politicians, their main aim is to gain power by whatever means, even by a coup. They don't care. Okay? But if you're a social activist, I believe there are certain ideals you really have to to hold yourself to. That you will not accept something, even if it's unlawful. If you're pushing for the rule of law, then you can't push it by whatever means. That's a problem.
You have to be values.
Yes. The thing, I think it's Obama who said this some time back, that Martin Luther, that the fight that you're fighting has to also meet the standards of whatever you're fighting for. If you're fighting for fairness, then your fight also has to be fair. Unfortunately, you have to observe those rules of war. And you have to be honest. So when I got the feeling that you guys just want to stop BBI for its sake, for political reasons, then I felt like you're not being honest. Because if you're doing it for political reasons, those are private and personal. You see, and you cannot hide behind public interest litigation, enjoy the benefits of public interest litigation when you know you are pursuing your own private goals. You see?
Because that can be flipped anytime.
Yeah.
When
because
someone
tomorrow
else...
it will be someone else who's there. So I felt a bit of a betrayal there, because I was like, okay, I thought we were here because... Remember, I asked the Court of Appeal. I told the Court of Appeal, you guys want me to be a respondent or to be a proponent? But you see, the High Court gave 18 issues. 18 issues which had been brought by 12 different litigants. How can all the litigants now all agree on 18? That's dishonesty. How can you suddenly agree on all 18 issues that are before the court? Either you guys are colluding, or you guys will present your position only, the one that you brought to court. So I told the court that there are things that I agree with some of the litigants. There are things I don't agree with. And the things that I will oppose or that I will defend most vehemently are the ones that I brought to court. Okay? These others, I will support the ones I support, and the ones I disagree with, I will again disagree with vehemently. Because I don't want to patch up here and destroy another part of the Constitution. You see? Or destroy one part in order to build another part. The Constitution is one, and we have to be honest to the whole. So that made me fall out with the other BBI litigants, and they actually got me out of their group. And I think they were being financed, and because I remember they would every lunchtime they would at break time they would go to, I think, Stanley, and they would be hosted there. At lunchtime they would again be served meals there and whatnot. And even at the end of it, I remember I mean, there was something going on. I didn't get it quite. I would walk across the road to go eat at one of these Somali restaurants there and come back in the afternoon and whatnot. So I got the feeling that there were other forces that were not coming out that were fighting that BBI process. Like these guys, some of these guys, I don't want to say all, but some of these guys were actually in court to fight a political fight. And I thought that was quite dishonest. You see? So now, anyway, all the way to the Supreme Court, I felt like the court misdirected itself in the High Court and even the Court of Appeal in pursuing the basic structure doctrine thing. The basic structure doctrine was not applicable in that particular sense. And now, in misdirecting itself, it made the ultimate pronouncement to be that the basic structure doctrine is not applicable in Kenya. You see, which now...
That is the Supreme Court now.
Yes. Which now, and I try to bring that distinction at the Supreme Court, which now, the problem with that is, what the Supreme Court told us is that as long as the procedure is followed, anything can be amended, including by Parliament. Now, if you know how the popular initiative is supposed to happen, it's so robust. It starts with collecting 1 million signatures. You know, collecting 1 million signatures is difficult work, as I told you, and it requires a lot of public participation. It requires a very robust... In fact, that signature collection, I don't view it as just merely formal signature collection. It is... Someone will only sign that document
once you've sold
it to them, because they are selling their signature. You see, they're giving you their signature. So they'll only give you that signature, 1 million registered voters.
It's nothing of scratch my back, I scratch you.
Yes.
So you must be adding value to them.
Yes.
For them to,
and it's 1 million registered voters. By the time you're getting 1 million registered voters, you will have had to explain to almost 10 million people who are not registered voters. You see? And so it's a robust public participation model, okay? The only thing I disagreed with the High Court is the High Court was creating another one. Yet the signature process is already that, as long as it's done validly, it's already that process the High Court was trying to prescribe, okay? So you will have to explain to so many people to get 1 million registered voters to support and endorse that process, okay? Once that has happened, and IBC has verified those signatures, you will then again have to go to the county assemblies. County assemblies are the closest representatives to the people. In fact, county assemblies are the most representative organs of the
society,
state, of the society. You will have to persuade them.
At least 24 of them.
Yes, 24 of the 47. You will have to persuade them to also endorse it. Imagine how much deliberation has to go on. And then you may still have to go to Parliament and may still now go to a referendum if Parliament refuses, or if any of those things require a referendum. Okay? So that by the time you're going to a referendum, there's so much robust communication that has happened that even if people are going to vote, they're going to vote having been informed. Okay? What happens now when you do away with this whole process and say, as long as a procedure is followed, then you can amend anything? What you're saying is that if someone decides to use a parliamentary route, okay, they will go to Parliament, they will get Parliament to pass it by 2/3, and then if it's something that requires a referendum, we will start the political bickering that usually happens every 5 years. All you need is you sema watu wetu na watu wao. You see, you did not have the robust deliberation among the people directly.
And yet, what
that a popular initiative would have
stood
done.
all through High Court, Court of Appeal, Supreme Court,
Yes.
was your submission on public participation. Actually, that
Yes.
what survived in the
Yes.
Supreme Court was
Yes.
actually your submission on public participation.
Yes. So the issue is, you are making it very easy to even amend fundamental things. Why? Because you're subjecting a constitution to normal politics. You see, you're subjecting
And
it
to
to
the
normal
politics of the day.
Yes,
to serve
the politics of the day. Because what will be the difference between the validity of a constitution and the validity of a president? If the constitution is elected by a referendum, and even you are elected by a referendum, sometimes you'll find like President Kenyatta got how many votes in 2017? He got 93%. At least that's the official position. The constitution got 60%. So are you saying that President Kenyatta has more legitimacy than the constitution? No. The reason the constitution has more legitimacy is because of the rigorous processes that led up to the referendum. The referendum was just one small part of it. It was the icing on the cake. But now, with the determination that the basic structure doctrine is not applicable in Kenya, and the Supreme Court went further and said, as long as you follow the procedure as laid out in the Constitution, then you can amend anything. What it was telling us is that Parliament can amend anything as long as it will end up in a referendum. But a referendum alone is just the normal elections we usually have. There's no difference between a referendum and the normal elections we usually have. So we can easily take away the right to property just through a referendum. Do you know that?
Yeah, that's what it says.
Yes, that's what
that's
it means.
basically what these rulings.
So I tried to explain in my submissions at the Supreme Court that let's not subject the Constitution to the normal elective democracy. The Constitution is much more robust than that. That yes, elective democracy has to play a role, but it is just part of a rigorous system. And that rigorous system is the popular initiative. The popular initiative ndo ilisema that it has to be a rigorous process. And in itself, it required 1 million signatures. They have to be verified. Then they have to go through all the assemblies. You see, parliamentary initiative doesn't go through the county assembly.
It doesn't?
It doesn't.
Wow, okay.
Parliamentary initiative only goes through the Senate and the National Assembly. And then the referendum. If it is something that is within those things, a referendum. Otherwise, a popular initiative is the only one that goes through all of them. The people themselves, IBC to verify, the county assemblies to pass it, the National Assembly to pass it, the Senate to pass it, and then if it touches on those things, again a referendum. You see? And so that made it that tomorrow, someone will not want to amend a fundamental thing, okay? Knowing very well that the people, they can polarize the people by the politics of the day, and so they go through the parliamentary route and then polarize the people. For instance, do you know if Parliament wanted to do away with devolution, then they can. All they need to do is polarize the people against the county assemblies.
Which I think is what...
promise the county assemblies a few things here and there.
When you spoke to some analysts way back in 2013, 2014, that was actually the intention. The strikes, the doctor strikes and all that, and the withholding of funds to they wanted to turn the people against devolution.
And it's very easy. You just say that, we devolved corruption, you bastardize it. You know that saying that if you want to
kill a
wants
dog,
to eat its children, it starts accusing them of smelling like goats. You start saying that it's corruption that was devolved, and you start showing how governors are misusing money and whatnot, so that now you clip some of the powers of the assemblies and people will support you. You see? And then promise a few things here and there to certain tribes here and there. Guys will go to a referendum and they'll vote for it. You see? But now what you've done is you've sacrificed the legitimacy of a constitution on day-to-day politics. That's what I didn't want. Or that's what 254 Hope did not want. Unfortunately, we had a pronouncement that the basic structure doctrine is not applicable. And so it leaves us in that gray area. Of course, we may still apply the basic structure doctrine and later on have it be applicable if we can demonstrate that the dispute that was before court was not a parliamentary initiative. You see? And therefore, what the court really meant, or what that decision meant, is that basic structure doctrine is not applicable in a popular initiative. But in a parliamentary initiative, it would be applicable. We still have some room for that.
Are you planning to try and get a review?
No. We don't need a review if you can interpret it in a manner that still makes it okay.
In a lower
Yes,
court?
yes. We have to wait for a dispute to come. And we hope that no dispute will arise. We hope that no one will try to amend fundamental parts of the Constitution through, say, the parliamentary route. We hope that no one will try to do the same thing as those ones were doing, so that even if, I don't have a problem with amendments, and amendments are good. They make the document better. They are meant to make the document better. So I hope.
I think we're already being prepared psychologically for that.
Yes.
With all these pronouncements of term limits and
Yes.
all this kind of, and the BBI process, the BBI 2 processes.
Do you know with the pronouncement that that the basic structure doctrine is applicable, and as long as the procedure is followed by the book, then any amendment can be done even by parliamentary process. The problem with that is something like term limit. Something like term limit means that any president can increase their term. Because what will you need? You'll just need parliament. Okay? You'll just need parliament, which the president generally usually has. Okay? Number 2, you will need your tribe and another person's tribe. One of the other
the big five.
The big five. The way we do our politics normally. That's all you'll need. And we'll increase the term limits. But something like term limits, changing a term limit from 4 to 5, from 5 to 4, changing the presidential terms from, say, 2 to 1, 7-year one, it may not fundamentally be changing the nature of the democracy. You see? But abolishing term limits, for instance, altogether, abolishing term limits, it fundamentally changes. Sindio? But that now can be passed by parliament. If we are to strictly interpret the Supreme Court's decision strictly as they worded it.
And I think that's
what
they want.
Yeah, that's what they want to rely on.
It's actually to abolish the term limits.
Yes, but if they try to abolish, we will still go and seek a declaration that the basic structure doctrine is applicable, and it cannot, and they cannot. That can only be done through a popular initiative. You see. Yes, we'll still seek to do that. So anyway, away with BBI, that one ilienda kaisha, and we are happy.
So what is 254 Hope now doing?
So now we're still touching on very many other governance and social issues. Like right now, we are having discussions around food policy, around climate change, and particularly with this GMO discussion and whatnot, we are really trying to come to the facts. What are the actual facts? You know, there's a lot of talk about, oh, GMO is bad, GMO is good, it will bring cancer, it will bring this and that. But what are the real facts? Food sovereignty. Like how can we still maintain food sovereignty even in the face of GMO? Because there are good things about GMO, there are bad things about GMO, there are consequences of adopting it. And so on and so forth.
Not just about health or whatever, even economic and and cultural and that kind of thing.
Even our own sovereignty, you see. So how are we protecting ourselves going forward? And to what extent can we allow the government of the day, that is the executive, to make such far-reaching decisions? You see. But we need to have these discussions. We cannot just be going to court anytime you disagree with the executive's decision. No. We need to actually ask ourselves tough questions. We need to have these conversations. That's why we were given the role of public participation. Let's participate in these things. Let's have the robust conversations so that by the time we are even seeking legal redress, it is only on the issues that are actual legal controversies. Okay? So right now we are, as 254 Hope, we are actually trying to have these discussions amongst ourselves. We are trying to come up with some policy positions on food security, on generally on food and land use and things like those. We are having discussions regarding health policy, But then there are also some actual now legal disputes that we are actually engaged in at this point in time. Number one is we've noticed that there's the devolved governments are taking advantage of the fact that they are many and nobody ever seeks to hold them accountable, and they are appointing in these technical positions, they are appointing incompetent people. You find the technical health person in a certain county is an ECDE teacher. What is that? The person has no background in health, no background in human resource, no background in policy, but because they have a relationship with the governor or a prior engagement with the governor makes them the chief officer for health. That's the person supposed to deal with a pandemic. If we go to that, that's the person supposed to deal with Ebola if it comes into, if it finds its way into the county. That's the person supposed to implement the policies. How? It's not possible. So we are actually currently in court with several counties who have appointed incompetent persons to hold those offices, and we've sued the county public service boards who actually approve those kinds of appointments and do very shoddy interviews. In fact, interviews that are predetermined. So they call for interviews, but they already know
just
who
to
they want.
Fulfill a process,
Just
but
to,
they've already selected
yes.
somebody.
And so we want to make the process of interviews more robust. We want to and we think it's there in our laws. We want to enforce that when you're called for an interview, you have a right to know what you scored in the interview and what everybody else scored in the interview and why the other person was shortlisted. In fact, when they shortlist, they need to give reasons why these ones were the ones shortlisted and why the others were not shortlisted. At the very least, tell the person who was not shortlisted why they were not shortlisted. Because when we apply, say I am applying to be to be the Director General of Health. There are those qualifications that are listed in the law, and then there are those that you will provide in the advert. If I am applying, it is because I believe I meet those qualifications, and I will provide evidence for that. So why would you shortlist another person and not shortlist me? There needs to be a reason. Is it that you found that my documents were fake? Is it that you found this and that about my documents? Is it that I was wrongly presenting myself as meeting the listed qualifications? You see, it's when we are not transparent about these things that people do their own funny things. There's this famous Justice of the Supreme Court of the United States who said that sunlight is the best disinfectant. If everything is
shine light into things.
If you shine light, all the pathogens disappear. Okay? And so if we make these processes more transparent, so that, fine, we went for interviews, right? Why did you choose this one over this one? What was the score? Okay? I remember when Airo, Vice Chancellor Airo, I think now he's the Vice Chancellor of Daystar. He sought to be the Vice Chancellor of Moi University. And they conducted interviews. And then you would see that on a particular metric, one person has given Vice Chancellor Airo 90, another person has given them 20%. What the hell is that? Are you telling us that you guys are so different in your assessment that there'd be such a variance?
That means you don't have a common criteria in that
But the
panel.
reason they do that is because someone wants Airo not to be the VC. You see? Or someone wants Airo to be the VC. You see? So one person scores them 90 because they want them to get a certain point and scores another candidate 20. Okay? But this happens because there's no transparency. Because the person who gave 20 will never be asked why they gave 20. You see, it will never be exposed to them. Because such a thing should be put in the news. Because it should be shocking to our conscience that people would behave that way.
And I think when you talk about shining light to some of these processes, from your experience from high school, university, getting into KMPDU politics, representing 254 Hope at the highest, what you call political court, is there hope for Kenyans? How do we shine light into our political processes? Because your organization is called 254 Hope. Have you lost hope, or is there hope?
No, there's hope. We wouldn't be doing anything. I wouldn't be here if I'd lost hope. The hope is alive. It's not going to be an easy journey. It's not going to be a quick journey. It's going to be a gradual journey, but the hope is there, and it doesn't even have to happen in our lifetime. For me, it's always a journey of progress. It's always a journey of progress, and we are making progress. Like, I'm pretty certain that, for instance, the issue that I'm telling you, those appointments and the interview processes and whatnot, once we get that determination, it will cut across. More people will be demanding it. You see, because now it is known that you must be transparent. So more people will be demanding it. It will make our governance better. There is something else we are also pursuing, but that's more at a national level. I've talked about the counties. Yeah, these are medical schools. Do you know those doctors who treat you at Kenyatta are not paid?
What way?
Apparently.
Oh, because it's a teaching and referral school.
Yes. And you know, this only happens in Kenya. This is why I was telling you that it looks like in Africa we have this problem where if you can take advantage of another, you will. These guys do the most work. They make Kenyatta so much money, but they're not paid. They pay University of Nairobi fees. Okay? Now they pay University of Nairobi fees, and then they are told because they are under training, they'll not be paid. So I look at it and I'm like, but these guys are working. They are required to have a license, a practice license. They are required, if you're a registrar, we call them registrars, the doctors in training at Kenyatta, we call them registrars. If a registrar is an un-Kenyan, they must have a work permit to be allowed to be a registrar. So we all recognize that these guys are working. They should be paid. It's unfair labor practice to have these guys give free labor. And you see, they can't stand up because, you see, we've made the system to be that way. So this person will not raise an issue. If they stand up,
they'll be victimized.
They'll be victimized. They'll never finish. They'll never finish their course. And you see, for them, they decided to just take it because, let me go be a neurosurgeon and that's it. But that's where now it's activists who come in. People who are willing to take the heat.
So are you challenging that in court?
Yeah, right now we're actually in the process of actually preparing the case, a robust case where we want to compel Kenyatta National Hospital, Moi Teaching and Referral Hospital, and any other teaching hospital that engages workers who are in training to pay them and to pay them fairly. So possibly by mid-November, December, we intend to have because that one just requires filing a case. We don't negotiate. We don't negotiate labor rights. We don't negotiate unlawfulness.
Let me ask you, Doctor.
We negotiate politics.
You're talking about filing a case.
Yes.
And in all these matters, nani anakulipa? That's what Kenyans.
It's something we've actually been really battling how we are going to be raising our money, because by and large, Dr. Muriuki and I and a few members of 254 Hope have actually been spending their money. Like, I'm on a salary, so when I need to file a case, or 254 Hope needs someone to file a case.
Why? Why are you doing this? Why you could be running your hospital, doing other things? Why are you doing this?
Maybe I get some satisfaction in knowing that I'm making a difference.
And the reason I'm asking that question is because we are coming, and this conversation is fascinating. We could speak for a whole day. So time is also.
Yeah, I think we are really
what would be like? How would you inspire other Kenyans who feel like they want to do something, give back to society, but sometimes they step back, they hold themselves back?
By and large, the worst never happens. Actually, that's what I would tell any Kenyan who is thinking of standing up to assert themselves and make things better. The worst that we ever think about never really happens. It never really happens. That most of those fears never really come to fruition. Most of the times, people actually want good governance. The ones who are in governance now are only taking advantage of the fact that no one really demands for good governance. Otherwise, if you demanded for good governance, they will give you good governance. You see, even they want good governance. Even those ones in governance, they too want good governance, but nobody ever
Holds them to account.
holds them to account or requires good governance. And so they take advantage of the bad governance that's there. Like the person who's in an office somewhere, they steal because they have a chance to steal. And because nobody will ask
There'll
them
be no
anyway,
consequences.
there'll be no consequences. But if you kept asking for accountability, they might frown at you a bit because of the discomfort you're causing. But after a while, they actually support you. I'll tell you for a fact, there's a county where we filed a case against Public Service Board and the governor, okay, regarding appointment of chief officers. And the people who are actually continuing to cheer us on are actually functionaries in that county government, because even they do not want to answer to an incompetent chief. You see? So they're the ones telling you, we know that what you're doing is difficult, but just do it, we'll support you. So generally, these guys actually want good governance. These guys actually want things to work. It's just that nobody ever stands up. And I would encourage other Kenyans, and not everyone has to be as courageous as those of us in 254 Hope, or those of us who stick our necks out and whatnot. And none of us is a saint, by the way. One of the things that we need to disabuse ourselves of is this doctrine of guilt. Okay? We need to stop feeling guilty. Because one of the reasons people don't stand up is because they too know they are guilty. They too know that if they were to be held by the same standard, they would fail. And so they don't want to put their necks out because they are afraid they'll be chopped.
Or maybe they did something somewhere.
Yes.
At some point.
They did.
They cut corners
And
somewhere.
yeah, they also cut corners. And so and whoever doesn't want to change the system usually wants to use that guilt that you have to make sure you don't stand up. But let's accept that we've lived in a broken society. Okay? We've lived in a broken society, and by and large, to one extent or another, you had to cut corners at some point to just barely even survive. You see? But don't feel guilty about it. Okay? You want to make the society better? Start making the society better now. I used to say that I don't even mind when a corrupt person becomes president. I don't mind when someone accused of corruption finds somehow their way, and because you can't really know. Just because someone was corrupt in the past does not always mean they'll be corrupt in future. And two, just because someone was not corrupt before does not mean they won't be corrupt in future. You see? People change. Number two, people they're not corrupt because they didn't have an opportunity. You see? So what you do is, let's strengthen the systems, let's ask for more accountability, and then let we ourselves try to make the society better. So that, yes, I may have cut corners in the past, okay, but I'm no longer ashamed, okay? I did that because that was the only way to make it through at the time, and I didn't know better. And now I know better, and I am trying to stop it. You see, and I'm trying to make the system better so that my children will not have to cut corners.
I'm sold. Now there's hope. Is there hope for a President Clarence Eboso sometime in the future?
I think
as we end this conversation.
I think my narcissism hasn't gotten to that point yet.
No, because basically you've talked about how you've been a change maker, and not just being an activist, but actually being in a system and changing that system.
I don't think, first of all...
And you've just called for people to step up.
I don't think at this point in time it is possible for someone like me to become president. To become president in this country, you require so much resources, so much, that you must have either stolen in the past, either directly or indirectly, to be able to garner that much resources. And then those resources are what beget connections, and which beget more resources. And I don't think, from my background as an individual, I can master that much resources. I don't think so. I may make it to other technical positions, which are also, which are influential. But I don't think I could make it to be president. However, we can change things. That's one. And two,
there's hope.
yes, there's hope. We can change things. But we can't change merely because I need to be president. No. But we can change things. And I had proposed, in fact, one of the 254 hopes midterm plans is to see if we can actually amend our constitution to have a mix between a parliamentary system and a presidential system, in the sense of a parliamentary democracy and a presidential democracy, in the sense that we can have 5 years or 4 years when we have a directly elected president, and then we have the next 5 years where we have
and next time,
yes,
that is what we'll discuss.
Yes.
This has been a very compelling conversation. I think we could speak forever and ever. I love the way you articulate issues, the way you think, and the way you have clarity. Unfortunately, time does not allow us to go on, but thanks for making time. Thanks also for espousing the spirit of Vutu, going out of your calling, the narrow calling of being a doctor, but being an active citizen, epitomizing the Utu na Uzalendo aspect. I can see you wearing the Kenyan flag. I think you're very inspirational for a young person. And I hope that we'll continue this conversation. I think we've just begun this conversation based on what Mzalendo Halisi Foundation is about. It's about highlighting the Wazalendos, people who are, umesema ulipu na mtu, you're actually spending your own money to do what you do. And I think we want to inspire more Kenyans to stand up. So thank you so much for making time.